Thank you, Rob, for that introduction. Thank you for having me as well. I'd like to start first. I have to give this disclaimer. Anything presented here is not legal advice. I'm not going to read the whole thing to you. And I'm personally not an attorney, like Rob was saying. I am an accredited representative from the Citizenship and Immigration Service. I'm going to go through a lot of regulations for you. We're going to talk about both the H-2B and the H-2A guest worker program. I understand the tourism industry is represented here, and that's going to be more the H-2B program, which is the non-agricultural temporary guest worker program. We're also going to talk about the requirements for employers to participate in this program, the differences between the H-2A and H-2B. I won't go into a lot of detail on the agricultural program, but I will highlight some of the differences. The programs are very similar now. Talk about the benefits to participate so you can relate this information to employers, and then also what FEWA membership does for their members. So FEWA is the Federation of Employers and Workers of America. Our membership consists of employers across the United States that are utilizing these two guest worker programs, as well as the workers coming from Central America, overseas, wherever they're coming from. So they become members as well. So let's get started. I do ask, I'm going to be going through a lot of regulations. Please feel free to stop me at any time if something's not clear. Even if we do bounce around a little bit, it does help throughout the presentation to have some interaction and answer your questions specifically as well. So I don't get bogged down too much on all the regulation stuff. So I'd be happy to answer any questions at any time. So let's begin with the H-2B program specifically. So what it is, it's non-immigrant work visa. Employees can work directly for the employers. They only have authorization to work for the employer that's sponsoring them at that time. They can bring as many or as few workers as you want. You can have a request for one worker, you can have a request for 200 workers, depending on what the employer's need is. Industries can range anywhere from landscaping, construction, hospitality, amusement parks. It can go on many different industries. One requirement is that you have to have a temporary need. So that's one of the requirements for the industry to be able to participate. Now you'll see there I say the temporary need has to be 9 months or less, and I have a notation there about the 2006 appropriations bill. We'll talk a little bit more about that in further slides, but basically the appropriations bill this year for the fiscal year 2016 has extended that from 9 months to 10 months, and we'll talk about that regulation change a little bit. Also, in this visa category, there is a statutory cap of 66,000 visas per fiscal year. That's for the entire country, coming from any country in the world, for the entire United States. So, again, the appropriations bill has allowed for this fiscal year a returning worker exemption, which means anybody who has received an H-2B visa within the last 3 fiscal years will be exempt from that 66,000 cap. So initially allowing 66,000 new workers for this fiscal year for the 2016, which is a big hurdle to come across. Congress put that in within the appropriations. It has not been active since 2007. That 66,000 cap was met last year, 2015. So an employer can go through this process entirely without this returning worker exemption. We talk about all the things they have to do, and then the cap be met and limited out, and then you don't get any workers for that. So returning worker exemption is pretty good. So let's talk about the temporary need. What different temporary needs qualify for this program? Seasonal, peak load, one-time occurrence, or intermittent need can qualify an employer to participate with this program. Many employers fall into the seasonal or peak load need. The two differences in the way the government describes this is here in the north, you can have a seasonal need where you shut down your business entirely. For your plowing snow, for example, or Christmas decor, 2 examples I have seasonal need. You're not going to do that year-round, and you don't have employees year-round. So you have it can be a 2-month season, 4-month season, whatever the case is. Peak load, a little bit different, can handle industries that do work year-round, do the same type of work. I use landscaping as a big example here because it's a lot of businesses that utilize this program. In the South, they can do landscaping business year-round, and they still have employees, but they have a huge peak. And some of you may have the same here in the tourism industry, where it slows down considerably, and you have full-time staff, but you just cannot fulfill that peak, and you'll fall into the peak load need. So that's the other one. Now, the one requirement for a peak load need is that you have to have permanent employees on staff year-round within the same job that you're looking to fulfill. So if you're looking for housekeepers, for example, when you have housekeepers on payroll year-round, and your peak season comes during the tourism season, that's what you're looking for. You'll have a peak in that. So the H-2A and the H-2B process involves 4 different governmental agencies, and we'll talk about their roles a little bit. The first agency you're going to be working with is the state workforce agency. Every state's involved for each employer that's going to participate in their program. And the role and the responsibility for the state workforce agency is to try to help those employees fulfill their peak load need, their temporary need, with U.S. domestic workers first. That's what we're really trying to do. And for every position that you cannot fulfill, then you can get certification to bring in foreign workers. So that's the state workforce agency's involvement. They're going to be posting the job that you have available within their internal systems online, and be referring applicants to U.S. employers that they feel that could fulfill these positions. Okay, and once you test the local labor market with the state workforce agency, you report that to the national office, the U.S. Department of Labor in Chicago. And they're going to make that determination. They're going to decide 2 things. One, if you tested the labor market correctly and you cannot fulfill your temporary need with the number of workers you're looking for, and 2, that you have a true temporary and seasonal need. So that's a responsibility of the U.S. Department of Labor. Now, they are an advisory only to the U.S. Citizenship and Immigration Service. So this is the 3rd department that's involved. They have final approval. They're going to take the decision from the U.S. Department of Labor to determine if, again, if you have a temporary need, make sure you're established business. They do go through that as well. And the U.S. Citizenship and Immigration Service will give you a final approval and notify the U.S. Department of State, which will be in the country where your workers will be coming from. So it's kind of a 2-pronged approval process for the employer to prove the temporary nature and that you cannot fulfill your positions with U.S. workers first. And then each individual worker that's going to be applying for a visa has to go through a personal interview at the U.S. Department of State, if it's going to be Mexico or Jamaica or wherever they're coming from, to make sure they don't have any type of criminal history, immigration violations on their record before they're actually granted a visa to enter the country legally.
Excuse me.
Yes.
I've already got a question.
Please. Thank you.
A lot of people know me, so they're like, oh God, there she goes. I think it's like one slide back, maybe. Peak loading.
Yes.
I guess. Did you say something about that in order to utilize the type 2, type 2, that you already have to have staff in place that are full time, that you just can't fulfill, that those folks can't fulfill. Do they have to? Did you say they have to? Do they have to be employed year round? Once that full time.
Yes, to be considered a peak load need, you have to have. If you're looking for a certain type of workers, that worker has to be employed. You have to have somebody on employment year round to be considered peak load need. If not, you just fall into this other category, a seasonal need. Yeah.
Okay.
So it could be one or the other, just basically describing what type of temporary need you have.
Okay. So the seasonal need, do you need that full-time person?
No,
okay.
not at all. Many of those businesses shut down entirely.
Okay, that's what I was thinking.
During their off season.
And is that per job description?
Per job description, that's correct.
So the process of testing the labor market is per company?
Per employer and per job description. So for example, if you have a need for housekeepers and you have a need for kitchen help, you'll be testing the labor market and running 2 separate advertisements for each job description, even if it's for the same employer. So you go through these steps for each job description. Okay, the H-2B program took some significant changes in this calendar year, which will be for the fiscal year 2016, and we're going to talk about these in more detail. First, they do have a national electronic job registry that's active now, so not only is your job positions that you have available going to be advertised through your state workforce agency in a local newspaper, but it's also going to be electronically on a national job registry. So an individual across the country can see and access these jobs, and they can apply for them. And we do get responses from Puerto Rico, for example, and people from across the country that can see these jobs available. So it's more on a national level. So it's enhancing the recruitment of U.S. workers before you're approved, these foreign workers, which is a great change. Reinstatement of the state workforce agency's role, which is where they're actually advertising for you, like we discussed, and a new definition of corresponding employment, and we'll talk about that a little bit more as we move on. Greater transparency by requiring employer disclosure of recruiters that are being utilized. This has been a big problem with the H-2B process, and the Department of Labor and Immigration are trying every measures to prevent international recruiters of charging workers for jobs here in the United States. It's unlawful for them to do that, unlawful for employers to charge a worker for a job to come over to the United States. So extra measures to try to cover that, extensions of H-2B programs to corresponding workers as well. Like we said, there's a national job registry for these workers. So if somebody wanted to apply for a job in Florida and wanted to come over and work for you, some of the requirements, the transportation requirements that we're allowing for these H-2B workers to come up from Mexico are going to require for those guys coming over to you as well. I'll describe that a little bit more in detail. Providing wage and hour department, independent department authority. They did not have that authority before. Wage and hour department is who enforces all these regulations and who will show up at the employer's place of employment to do audits and that thing. And they can show up either way without the participating in the H-2B program, so they can audit this program as well. So in regards to the State Workforce Agency, the timing of recruitment of the application has been extended through the new regulations. Before, each state would only be required to open up a job order, which is going to be the job duties and the job position you're trying to fulfill for only 10 days. And that's how long they would be required to submit you referrals to fulfill those positions. Now they're required to do it up to 21 days prior to your start date. So if your season begins April 1st, you can start your application process with the State Workforce Agency 90 days prior to April 1st, which will be January 1st, give or take a day or two. And they have to keep that job open for up to 21 days prior to that April 1st start date. So that extended quite a bit from 10 days, which gives the State Workforce Agency more time rather than just 10 days to get referrals to those employers to try to fulfill their need. Yes?
So locally, like here in Michigan, our posting is through the mytown.org. So that's where that's the statewide system. So that's where the job would be posted.
Yes.
Okay. So then would that come, if it's not filled until 21 days, is the employer still applying to the state workforce agency, or how does the local area fit into that?
Well, they'll be reporting to the national office in Chicago, actually, on what applicants they received. They actually have to submit a recruitment report with every applicant received and who was hired for the position and who was not.
So locally, we would probably then go to our state workforce agency to show that this was on there for 21 days.
That is correct, and the state workforce agencies actually communicate back with Chicago, the National Processing Center as well. So we talked about the 21 days prior to the start date of need. On top of that, you'll be running the employer is responsible for 2 newspaper ads in a local paper. One has to be a Sunday. There's still required print advertisement. Again, the employer will also have to, if they're not collected through a bargaining agreement, not a union employer, they'll have to post the position for 15 consecutive business days within their office. So we're taking all these additional measures. All this is new for the 2016 season in order to try to fulfill the jobs of the U.S. workers first. So this is what the program has changed to. You can see you'll have to contact a union if you're a union employer. Now these are pretty basic, but are written in the regulations now. No discrimination in hiring. Minimum productive standard. This may apply to some of the fishing companies here, or depending on if you're not paying just prevailing wage, or you're required to use an example that we use down in Texas coast. They have to shuck a amount of oysters per pound per hour. If there's any type of minimum productive standard that you're doing, then you have to put that in the job order, and you have to state that up front. That gets posted on, within your employment, posted with the state workforce agency, posted at the National Job Registry. So we have to disclose all this information up front before we can bring in these foreign workers. Foreign recruitment, we talked about. We have to submit copies of any foreign recruiter that you're in contact with to make sure they're not illegally charging these workers any type of fee. It goes on more often than not, unfortunately. The employer has to sign, the agent or attorney has to sign to make sure that they are not knowingly, unlawfully getting any money from these workers. Even if you're not doing an international recruiter, if you have contacts working for you now that have ties back to, Mexico, Central America, overseas. I know some of you may be involved in the H-1B program in the past, or maybe J-1 program. If you have ties to those workers, we just got to make sure that anybody is not receiving money just to be put on the recruiting list. So that's in the regulations now. It's something you have to sign a contract to submit to the Chicago, the national process. So this is also, with the agent, I'm referring to somebody, if you do outsource the H-2B program, that's somebody like ourselves. If we're handling it for you, we're signing off on all this documentation that goes to the government, just like each employer will be signing off on this information. So they have to also contract with us to make sure we're not charging any of these workers any unlawful fees. So the job opportunity itself can be temporary, like we talked about, peak loader, seasonal, but it has to be a full-time job. It has to be at least 35 hours to be considered full-time through this program. Of course, the work week is defined, 7-day work week, but you have to at least offer them 35 hours per week. You can offer them more, they just set a minimum.
Well, when you don't reach the 35 hours, what happens? Let's say you have enough work for 20 hours for the week.
For the week, there is a 3/4 guarantee, and we'll talk about that a little bit more in the slide, but it's within a 12-week period as well. So we're going to have, if you're working outside, you'll have some rainy days or whatever the case is. But in the initial job order, you have to be offered a full-time position. And I'll go to the corresponding as well. I'm sorry, the 3/4 guarantee. I want to talk about corresponding employment. It's a little tricky situation right now because through the appropriations bill, the Congress has passed that the U.S. Department of Labor cannot utilize any of their funds in the fiscal year of 2016 to enforce this regulation, but it has not been vacated from the regulations itself. So once that appropriations expire, they can't enforce it. We'll have to see what happens come October, 2016 when that expires. But what this means, it's just helping protect more U.S. workers. So if you have other individuals that are doing the same job duties, the same job tasks that are listed on the application, or just doing the same job duties in general within the same area of intended employment, all these things that we're talking about, the prevailing wage that we'll get to, and all the other job requirements, any productive standards, are going to be applying to those corresponding workers as well. So covering those U.S. workers that are doing the same jobs. Again, that's not enforceable right now for this 2016 season. It's all new. There's a few things that were included in that appropriations bill, that returning worker exemption, this corresponding employment, and then a few other things that we'll touch base on. Disclosure of offered wage. This is some of the information that has to be going in the job order. Of course, you have to let them know what the offered wage is. The prevailing wage is something that, an application that has to be submitted to the U.S. Department of Labor. I did look it up for certain counties. So what you're doing is you're sending an application with all the job duties, all the job description to the U.S. Department of Labor before you even start this 90-day process. So they're going to set a prevailing wage based on the H-2B program and take into consideration all the counties they're going to be working in as well. So if you're going to be working throughout the one area in multiple counties and the wages are different, you're going to be required to pay the highest wage on your application. They're also considered one application for one area of intended employment. I don't know if many industries do a lot of traveling, but they're considered one area of intended employment anywhere you can go and come within a daily commute. So if you're going further than that and you can't get back to the home office or the location, then you need to file a second application. But I did look up the prevailing wage just for an example for, say, a housekeeper in this area, and it's at $9.68 an hour for the H-2B wage for Delta County. So just to give you that. This used to, the wage rule before this used to allow for a Service Contract Act wage or a Davis-Bacon Act wage, but the new regulations do not allow that anymore. Frequency of pay, normally never a big issue, but you have to pay at least every 2 weeks. Some industries, we're paying monthly, that's not allowable on this program. You have to pay at least 2 weeks. So if it's weekly, that's fine, but at least every 2 weeks. If you have any incentive in their base wages, you have to disclose that up front. If you offer any type of bonuses or you can get a raise, all that information has to be put up front. So that's just what has to be included in the job order as well. Now this is a new requirement after the 2015 regulations. All deductions, of course, by law, they're going to be paying all federal, state taxes. They can do any voluntary deductions if they're going to be participating in any 401k or anything like that that's voluntary on their end, of course. But any deductions that are not required by law and are not disclosed up front in the job order are not permitted. We'll talk about a little bit of those. So in regards to what they have to provide for them, I think uniforms is one of the biggest controversies that employers find that they do deduct at times for an employee's uniform, but anything that's required for the job that you have to now give them at no charge. Tools, supplies, uniform is one of them. Anything that's required for the position. We have industries that require steel-toe boots. You have to give that to them at no charge. So if it's required for the position, you can't charge them for it. Now this gets into the 3/4 guarantee, like Rob, your question. The regulations state, and it's not vacated again, but the regulations state that a minimum is 35 hours per week. But if you put on your job order that you're requiring 40 hours a week or 50 hours a week, depending on the industry, someone works 7 days a week, whatever the case is, whatever your application states, within every 12-week period or 6-week period, depending on how long your job orders for, your contract is for, you have to offer them at least 3/4 guarantees. So if you do have many rain-out days within that 6-week period or 12-week period, you're still going to have to pay them at least 75% of that job. Now, those regulations are still valid. It have not been vacated again through the 2006 appropriations bill. Congress has not allowed any funding for the Department of Labor, Wage and Hour to enforce these regulations. So that's something that's not enforceable for the 2016 season, but it's still there. And the Department of Labor, Wage and Hour, as you'll see, they have audit authority for up to 3 years after you file this one application. So we'll see what happens after the appropriations bill is renewed, or if there's a continuation coming October. So a lot has to do with Congress on that. Earnings statement, you have to keep accurate pay and hours, of course, during their paycheck. I mean, this has to do a lot with the 3/4 guarantee as well, because you will have individuals that don't show up. And when we talked about corresponding employment and 3/4 guarantee, those provisions go to anybody who's doing the same job, again, with that corresponding employment. So the 3/4 guarantee would apply to them as well. So your U.S. workers that are doing the same job duties and same job tasks are having to meet those requirements. Now, sometimes these workers won't show up. So you would have to keep track of not only the hours they actually worked and they paid for, but also the hours you offered them, because those offered hours will go towards that 3/4 guarantee. If you have individuals that repeatedly don't show up week after week and you're still having them on payroll, at least you can show that you did offer them, 75% of the hours, and you don't have to go and pay them those hours that they did not work. So it's just more paperwork and more things you have to keep up with.
Do you see a lot of people that don't show up? I mean, is that a problem that you
Not for the H-2B workers. In the agricultural side, sometimes we do see that for the H-2A workers. But again, when this covers corresponding employment, you may run into that issue with your domestic workers. So you just have to keep track of all the hours. No layoffs. They want to make sure, the Department of Labor wants to make sure that you're not laying off any U.S. workers just to bring in these foreign workers, to take their jobs away. So many of us are seasonal or temporary, and you're going to lay off by the end of the year. But if you do that, as long as you lay off the H-2B workers first, and then your U.S. domestic workers, and again, this is per job description, so this is for that job, whatever position you're fulfilling. And you can see that 120 days before your date of need, you can't have a layoff. And then if it's during the season, then you just have to lay off your H-2B workers first. So what the Department of Labor does not want to see is you bring in your H-2B workers and then lay off all your U.S. domestic workers. So some more protections for the U.S. domestic workers. Yes, sir.
So how do you lay them off if you have to pay them 35 hours?
That's during the end of the period. You have to pay them 35 hours a week, so you have to state to the Department of Labor what your period of need is. So if it's April through November, your layoff shouldn't be through until November when the workers are going to be going home. So during that period of time, they should be getting 35 hours.
So you can't lay off during that period of time?
Correct.
Because you couldn't lay off one of your other workers when you had these employees?
Correct. You could, but you would have to lay off your H-2B workers home first and send them home.
But,
If you have a layoff, and you'd have to meet the 3/4 guarantee.
right, so you would have to pay them anyway.
Right, right. There is some provisions now, act of God and, other things that could get you out of the 3/4 guarantee if you just had a storm where you just couldn't do your work. So there are some provisions that will let you out of that. Again, it's not enforceable for this 2016 season, but there are some provisions if something was to happen or a disaster was to happen where you could not do your job your season. This takes a lot of play in the agriculture as well because the same provisions are in the agricultural program, and if something destroys their crop and they don't have to work, they're not going to pay them for 75% of their work contract when they're just not working. So there's some provisions there for that. Transportation and other expenses when they're coming to the place of employment from their place of recruitment. Again, this is for the corresponding workers with that National Job Registry I talked about earlier. But this is saying that anybody coming from Mexico, Central America, overseas, the employer is going to be responsible for their transportation, their expenses of their transportation. It's considered a benefit of employment for the worker, so it falls under the Fair Labor Standards Act as well. So there are two different provisions here that you have to look at. First are the H-2B regulations and then the Fair Labor Standards Act regulations. So what that means is, since it's a benefit of employment for the employer, the transportation expenses that they paid for that airplane ticket or bus ride out of pocket, that needs to be reimbursed to them upon arrival. Because if it's not within that first pay period, that work week, that deduction or that expense that they had out of pocket could take them below federal minimum wage out of that first work week, which will put you in a FLSA, problems with the FLSA with those deductions below federal minimum wage. So best practice is to reimburse them 100% of their travel expenses, and that's from the place of recruitment. So this could get expensive if they're coming from overseas. A lot of the hospitality industry does use Jamaica, that we experience, and they have to reimburse them for those plane tickets. Now, as you'll see here at the beginning, it says only if they complete 50% of the job order, and that's the H-2B regulations. So basically what they're saying on the H-2B side is that you have to reimburse them 100% once they fulfill 50% of the contract, but on the FLSA side, you have to make sure that those deductions do not take them below federal minimum wage. So it's hard to meet both. So technically, you could reimburse them 100% upon arrival for those deductions that do not take them below the federal minimum wage, and then you can have them pay you back, slowly. That way those deductions don't take you below federal minimum wage. But once they meet 50% of the contract, to keep up with the H-2B regulations, now you have to pay them back 100% because they work for you for 50% of the contract. You can see how that could be confusing. It's hard to explain, but best practice again is just to reimburse them upon arrival to make sure you're in compliance with both regulations on that transportation.
You can include transportation back.
Yes, transportation back as well. Same scenario. Now, it's a great question because we talked about layoffs and we talked about, even firing an individual. You will still be responsible for the transportation back if you fire an individual. You'll have to report that to the U.S. Department of Labor and Immigration. Basically, the employer has to do everything they can to try to get that individual back in the country if you fire them for any reason. Employer is responsible to pay for their visa-related expenses. This is $190 per worker coming from any country in the world, so you have to pay for those expenses as well. It falls in the same category as the transportation and the transportation expenses and the FLSA requirements. So you'll be reimbursing them upon arrival for the $190 US plus the transportation. These are just prohibited fees, just saying that employers and employees cannot charge the workers. Some basic requirements here: you cannot impose on any U.S. workers restrictions or obligations that are not imposed on the H-2B workers. just, fair treatment there as well, but it's actually written in the regs, so it's something that the Wage and Hour Department will talk to your workers when they do come and audit an employer to make sure that they're in compliance. So the minimum benefits go to the corresponding workers as well, so pretty covered that already. No unfair treatment, again, this is within the regulations. The employer will not unfairly treat both the U.S. workers and the H-2B workers that participate in this program. Pretty straightforward information, yeah. One of the requirements as well, the workers' right poster, the U.S. Department of Labor does provide some of these regulations we're talking about, the 3/4 guarantee, the minimum hours per week, a lot of that information on a poster that's required to be put in the employer's place of business, both in English, and then they also have a Spanish version available for now, so you have to put in the language that they speak in. So they're aware of these regulations when they're coming to work for it as well. Now, the job order we talked about that gets posted with the workforce agency and the National Job Registry, everything, that actually has to be translated if they do not speak English and given to every worker before they process their visa. So this will be given to them in their home country. If they're Spanish speaking, it has to be translated into Spanish so they understand all the requirements of the job, all the provisions, all the assurances in regards to the transportation, what you're going to reimburse to them, what the pay is per hour, if there's any minimum productivity, all that has to be in writing in the job order. What's going to be posted on your state workforce agencies online is what's going to be posted in your advertisement, and then also given to each worker that applies for the job here locally and the foreign workers before they apply for their visas. That's important. We talked about one area of intended employment in regards to a certification area. Now, this is important because every county could be different in regards to their wages for those employers that actually travel and do work in multiple counties. So we cannot place any H-2B worker outside of the certification of the application. So if you list 3 counties on your application, they can't go to the 4th neighboring county because that prevailing wage could be different. And you did not offer that wage to the U.S. domestic workers when you're testing the labor market. There may have been individuals in that county that wanted that position, as the Department of Labor stands. So they're going to be restricted to what is on the application by job description and by county. So they cannot do that, and that has a lot to do with the corresponding workers as well. So if the neighboring county is more per hour, then you have to raise the wages for everybody. So you're restricted to what's on the application. This is early separation. The question you had, if you have to pay for return transportation, it also covers what your responsibilities are if anybody returns home or before the contract is ended. You'll have to notify the ETA, which is the Employment Training Administration, division of the Department of Labor, within 2 work days of any H-2 worker and any corresponding worker if they're no longer working for you in that job description. Of course, you'll have to be responsible for their return transportation from their place of recruitment. The only time you're not responsible for the return transportation, as you'll see there in the first bullet point, is if they abandoned the job. And there's no way for you to pay for the transportation if they just didn't show up to work and you don't know where they're at. Your only requirement is to notify the government within 2 days if they're no longer working for you. And then you're not responsible for the transportation. But even if you fire an individual for cause, even if it's something as drastic as stealing from you or something like that, you still have to pay for the transportation. These are just some of the compliance violation penalties where the Department of Labor has their enforcement, wage and hour, and Department of Labor themselves, ETA, have debarment authority. You can see some of the penalties can be pretty extreme. This can be $10,000 per violation. That's on the high end, of course, and this really is when you're not paying an individual worker the right amount of money, the prevailing wage that you said. Now, per violation can be per worker. So if you're employing 10 workers and you're not paying them the correct prevailing wage, you can see excessive violations here. This is per employer, of course. So again, the employer will retain all documents for this program and the H-2A program for 3 years. So that's how long the wage and hour can go back and audit you and enforce some of these violations is for 3 years, even if you're not participating in the program anymore. So you have to take that into consideration as well. These are some of the reasons why the Employment Training Administration could revoke your certification during an audit scenario, if there's been any mispresentation of material fact. What this means is the Department of Labor, what we've seen in some of the cases we've seen come across, the Department of Labor requires you to detail the job duties and job descriptions that these workers are going to be doing, which affects their prevailing wage. If an employer is not truthful on the application and does not put what that job description really is because he's trying to get a lower wage from the U.S. Department of Labor, that's a misrepresentation of material fact, and it can debar them, and fine penalties, of course. You have to comply with any audit scenarios, of course. You have 72 hours to do that if they do show up at your doorstep. Wage and Hour also has independent department authority to not only the employers, as you'll see here, but also as the agents and the attorneys who's filing these applications for you. So it's very important, on who you're working with to make sure that all the information that's going to be submitted to the U.S. Department of Labor is true and accurate, and that, you're not in any gray area, because not only can they debar the employer, but they could actually, if it's something that we're doing as an agent, they could actually turn and debar us as well. For up to 5 years now, it used to be just 3 years. So on the applications you're signing, that you're submitting to the U.S. Department of Labor, everything's under penalty of perjury, and all these requirements are listed on all the applications for each employer to sign off on and their agent. So it's very important that this stuff is true and accurate. Talk a little bit about the agricultural program. And there's no cap limitations. We talked about 66,000 visas for the H-2B. No cap limitations there. The corresponding employment is still applicable to the H-2A program. It does, right now, the H-2B is not enforceable because of the appropriations bill. The wage, there's not a prevailing wage that is issued on the H-2B program, like all agricultural is divided into state with adverse effect wage rate by state. It's adjusted every beginning of the year. Right now for Michigan, it's $12.02 for any agricultural need participating in the H-2A program. Of course, with agricultural, there's not overtime and some other things in the agricultural industry that you have to pay. So $12.02 is the standard rate. Some of this can be based on piece rate. If you're picking tomatoes or whatever the case is, you can be paid a piece rate as well, as long as it's disclosed in the job order up front on the agricultural need. But if you're requiring a piece rate, at the end of the day, you still have to pay them $12.02 per hour. So if they didn't pick enough apples to meet the amount of hours that they work, $12.02, you're still required to pay them a minimum of that, where that adverse effect wage rate and where it's at in Michigan right now. The 3/4 guarantee is still in effect in the agricultural program. It's based on the entire contract. The H-2B program is divided into a 6-week or 12-week period, depending on how long your contract is. The H-2A program is not. If you have a season that's lasting 4 months, we're going to take 75% of that 3 months. Or if your season lasts 8 months, we're going to take 75% of those months from the entire contract. Big difference on the H-2A program is housing is provided at no cost. This is where the state workforce agency is also involved, where they're doing inspections on the housing. If it's not an apartment complex or something like that, then it's a privately owned house. They will do an inspection on that. OSHA will come in and make sure the housing's up to standard. But that is no cost to the workers at all. So it's another employer's expense when you participate in the agricultural program. And also you'll see meals are provided. You can either do 3 meals per day to each worker, or if the house you have to furnish the cooking utensils, and then if it has a kitchen in the house, you don't have to run the meals. So either the meals or facilities to cook their own meals, but it's responsibility of the employer as well. And this is strictly on the agriculture program, not on the bee side. So all that being said, I wanted to touch base a little bit about why do employers utilize it. It's a lot of things that they have to go through, a lot of restrictions, a lot of requirements. It's basically why the association exists, because all this information is available online, all the applications are free of charge, etc. But it's there's so many rules and regulations that you have to stay compliant with these employers need to turn to somebody and hire and make sure that they're staying in compliance with what they're trying to say. But, you know, when you do get involved and you do go through and obtain your certification, you will have an abundant labor supply. You know, once you have that pipeline full of workers, anybody who's been involved in hiring these individual workers, the return rate is so high because the amount of money that they're making in their own country is nothing compared to that $10 rate, you know, $9.50 rate that you'll be paying on the H-2B side. So the return rate is very high. One of the biggest benefits is the cut down on training costs, cut down on, you know, retention on your employees that you have each year. They're going to be legal workers. They're going to get valid Social Security numbers. They're going to pay all taxes, federal taxes, Social Security taxes, state taxes if you have them. All that they'll be paying, all taxes, of course. Repeat workforce, we talked about higher productivity with less turnover. We hear the stories all the time, you know, when you're trying to fulfill your need, the employers are trying to fulfill their need. You know, you run out of people. I know that the state workforce agencies are sending over as many applicants as they can, but sometimes the turnover gets high. The individual doesn't want to work. And right now, this is the only mechanism to bring over legal, temporary, non-agricultural laborers for the H-2B program. Of course, the H-2B program, and they can only work for your company. So employers goes through this entire process. You know, process in itself with the 4 different agencies can take 5 months. You know, we start in the summer last year to prepare for spring of this year. Is how early we start on the paperwork process. But they can only work for your company. When they receive that visa in the U.S. Department of State in their home country, there's going to be your company name printed on there. The Social Security number is going to print that they can only use that Social Security number with work authorization only. So not only can they use that Social Security number, but they have to have that visa to back it up. Now, the Social Security number never expires, right? You know, once it's issued to them, but it's also going to say, always going to say with work authorization only. So they have to have that backup document as well. Yes, ma'am.
Is this only for private companies, or can a county go through this process?
A county can go through the process as well, yes, but it has to be some type of established business. The person, like we've had calls about, you know, getting housekeepers or things like that to a person that would not apply, but a county can apply. We have state parks that, you know, participate in programs and things like that as well. So some of the benefits on the workers' end, we talked about Social Security number, you know, the illegals coming over from Mexico is more what we see. You know, they're paying outrageous amount of money just to come over undocumented, unfortunately, risking their lives, things like that. They can't obtain a driver's license if they're required to for the position. It's going to be only valid for the amount of time that their work visa is valid, but they'll have to do it every year, but they can obtain a driver's license if it's required. They can get their taxes back and travel freely across the border. They're actually insured, multiple insured visas, which is a big benefit for these workers. You know, if they have a family emergency or something, they can travel back home and back to you as long as the employer allows it, without any additional cost. You know, any type of family emergency that they need to get back to. When they come over undocumented, they just can't afford to do that. You know, they're paying, as you can see, $1,700, $55,000 per worker. They can't go home with their mother passes or something like that. They just can't. They're trying to take off that debt. So it's a great program on both ends, for the employer and for the worker. So who are the prospective H-2B workers? They have to have a temporary intent when they're going through that personal interview. They cannot have a permanent intent to remain in the United States or also be denied their visa. So they have to have some type of family ties, economic ties back to their home country, something that tells the Department of State that they're going to return, because it's a temporary visa. They cannot overstay that, or they should not overstay their visa. That's what the Department of State job is for. Now they can deny their visa just based on their assumption that they think they're going to overstay. You know, so it's up to the applicant to overcome that assumption. Every applicant, when we're dealing with the Department of State, is felt that they're going to overstay their visa. That's how the Department of State interviews them. So they have to overcome that assumption. It's not meant. These programs are not meant to legalize undocumented workers. You know, we get this question. More often than not, you have somebody that's been working for you and it's really a great worker. You really want to help him out. You know, you find out he's been under the radar. This program is not meant to legalize that individual because now he's had immigration violations. Right? So when he's going through a personal interview at the Department of State, they're going to do digital fingerprints, background checks, and one of the questions they're going to ask him is, have you been living in the United States undocumented? If they have, he's going to be denied the visa. So this program is not designed for that. That's the entire comprehensive immigration reform that Congress has been trying to take up for the past 10 years in regard to how to address the 20 million undocumented workers that are here now. So these programs are not for that. Best referrals from your current workforce or your current community. Had this question come up a lot. If you don't have ties back to another country, where do you turn? There are international recruiters that we work with that can recruit some individuals for you. Of course, at no charge to the employees. They can charge the employers, and they will, but they cannot charge the workers. But the first step is really your community, because they're in the requirements on the H-2B side. There's nothing, regarding to housing. They're going to need a place to stay. They're going to need to get to the grocery store on the weekend. Just living, if they have some ties to their community already, it's a much easier process. But again, once you get the same workers back year after year, or once you start that process, you'll have, referrals that you can turn to, as many as you like. So a little bit about FEWA. We are a nonprofit association. Our employers are the ones utilizing this program. We have a personal guide that guides each individual through the entire process. We meet with the workers personally in Mexico and Central America. We do not outsource that process. We do have contacts in Jamaica. Actually, we've done a lot with Romania as well. The workers become members too, so they have a toll-free line that they can contact us directly. Our entire staff's bilingual. They get a membership ID card while they're here in the States, so if something comes up on their end, or if they feel an employer is not doing some of the requirements that they're supposed to, they have somebody to turn to. And if it is any extreme measures, then we would turn them over to the Department of Labor. We have lobbyists in Washington, D.C. These programs are always changing. We just talked about the 2016 regulations. This has been a big change since last time we've had overhaul of regulations was 2008. So we're always having a lot of these programs to make sure they're still in existence for employers, and the workers are members too. So that's a big benefit. We continue communication throughout their year while they're working for the employers directly. So they had somewhere to turn to, and a lot of these in Washington, D.C. Of course, we do have attorneys on staff that keep up with all these regulations, and it's always something new. There's notice of deficiencies is what that stands for. There's appeals, there's audits, that the employers need assistance through that work directly with the attorney. These are just some of the associations that we're involved in, some of the committee chairs in D.C. and basically around the agricultural and H-2B program. So, I won't read all the citations, that's just so you know where all this information was coming from. Of course, all the legal side of it. So if we have any other questions, I'll be happy to answer those now. Yes, sir, in the back.
How and when are the year-end tax information issued for each employee, so like their 1099 or W-2s or whatever the form is for the H-2B workers or H-2A workers?
It would be the W-2 for the H-2B workers, because they have to be employees of each individual company. It's a great question, because a lot of employers still do work on the 1099s, but through this program, they're still on a 1099 employee. They're not considered employees. They're still contractors. So that's not allowable through this program because they have to be in complete control of these individual workers. So they have to be, and they can, the same tax time, a lot of times they return home depending on the season, and they don't handle their taxes until they return the next year. So it really depends on when they're going and traveling. Same time period.
But would you have a mailing address for the worker, or
yes, you would have, if the worker's not returning the next year, you would send it back to their home country.
Okay.
Yes. Yes, ma'am.
I was working in the little cities or Western Italy, and they have been for a number of years utilizing other workers out of Jamaica. And I think it's the same organization that they're recruiting that Northern Ireland is too. But I remember them talking about specific requirements for advertisement in the paper, and is there like a dollar amount or a time frame that they have to advertise? I know you talked about that 20 days.
Right, that's with the State Workforce Agency. Is it agricultural or?
No, yes, it was.
Oh, ski resort, okay, so.
We're operating lists.
Right, yes.
Different functions that they have.
Yes, the only requirement for the actual advertisement in the printed newspaper is 2 days. 2 days within a help wanted ad. One has to be a Sunday. Now, that time that they have to do that is within a 14-day window. Once we file the application to the U.S. Department of Labor, they in turn tell us specific instructions and everything that has to be included in the advertisement. And you have that 14-day window to run that 2-day help on that. So it's only 2 days.
Is it just in the local area then? Because they were advertising outside of their local area even.
The only requirement is that it has to be a daily newspaper, which means it should cover, most of the area. So if it's not a daily newspaper in your local area, and it only runs once or twice a week, and the one specific requirement is that it has to be a Sunday as well. So that's kind of their mechanism to make sure that you're advertising in a large enough paper that if they have a Sunday paper and they run daily. So you get better circulation there for the U.S. applicants. Yes, ma'am.
And I think we went over it too. So say a hotel or say a restaurant hired a worker, they utilize them, possibly, they hire them in as a housekeeper. And then they're a good worker, they utilize them, they figure also for something else, because maybe it's a smaller property or, whether it's grounds or whether it's front desk or whatever it happens to be. So with that, you were saying they would have to pay the prevailing wage of whichever position, let's say those 3 positions was the highest.
Right.
All the time, whether they were housekeeping or not, because you were using them possibly for the front desk.
Yes, that is correct.
And you know what I'm saying?
Yes, yes. It's, you would actually have to have a separate application for each job description. If it's that.
For that one worker.
For that one worker. For them to be able to cross lines that way. So they can't come in as a housekeeper and then maintain the grounds as well. It would have to be a certification for groundskeepers and a certification for housekeepers.
Would you have to fill out, okay, so
2 advertisements, everything.
2 advertisements to everything?
To this entire process with the 4 different agencies for each job application. Now, if there's some crossing, then you can do a combination of 2, but for that example, that's not. If it's hostess like in a restaurant, if they're doing dishwashing and bussing tables, that could be a combination of 2 job duties, for example. Even if they're doing some landscaping and snow removal for a portion of the time before they leave, because it still has to be temporary, that could be a combination of job duties. Something pretty close, but not nothing.
Because I'm thinking, like, for example, like say somebody's got a restaurant. They've got local workers, maybe hostesses, okay? They hired a H2 to work as a waitress. They do a really good job as a waitress, and that's what they came in as. But all of a sudden, this local worker just didn't show up for work, right? And all of a sudden, you're like, I got to fill this job, busy. So I move them over to hostess job. So I've got to, what happens at that point? You've got to contact the agency, fill out another application, or do you have to do this whole 20, you know what I'm saying?
Yeah,
That whole advertising thing?
it's not as flexible that way because you could not move that worker over until you have a certified application from the Department of Labor for that position, because the Department of Labor wants to know that you offer that job to U.S. domestic workers first, because you didn't advertise for hostess, you advertise for waitresses. So you can't just move anyone.
So all of a sudden, I don't have a hostess. That's what I'm,
Right, no, that's exactly, that's true, yeah.
I still got to go out and advertise,
Yes.
even though that next day I
Yeah.
don't.
Now, if she moves up in the company over time and works away from a waitress to a hostess, then next year you can apply for hostess and she can take that position. But yeah, there's not a lot of flexibility there because they just want to make sure the labor market's tested correctly with the correct wage and everything for the different jobs. Yes, ma'am.
Do you think anecdotally there's any thoughts out there as to the size of a company or the number of employees a company has where the return on investment kicks in for doing this whole process? Or if you're too small to say, maybe this is just too much work to even make it worth your while?
Right, that's a good question. We have employers that really, they say the line is right at 4 workers. We do have some unique employers that bring over 2 as well, and they've had the same 2 returning workers, so it's worth it for them, for those 2 workers, even in the hospitality industry, so, but 4 workers really makes it, return on investment, because it is expensive, there's filing fees that go to the government, at different levels, at the immigration level, at the Department of State level, membership fees or legal fees, whatever the case is. So, 4 is normally a good line that we see that our membership revolves around, that really return on investment there. And then, of course, you have your employers that are bringing over 100 plus workers, depending on the industry. Unfortunately, the process remains exactly the same if you're doing 1 worker or 100 workers, so that's why it depends on the business. Yes, ma'am.
So, as far as the agriculture part of it, you said the housing, the meals and all of that, you said it was different for non-agriculture.
No, it's not a requirement through the regulations.
So what are the requirements in?
Well, through the regulations, there are none. The financial responsibility for the housing and the meals and everything is on the employees, the worker themselves. Like I said, if you are using an international recruiter or they don't have anybody in the area, naturally they're going to need a place to stay when they arrive. A lot of employers choose to put them in hotels until they can show them the area, they can choose an apartment, etc. But again, the expense is on the employee, not on the employer, on the non-agricultural side. Yes, ma'am.
Thank you. So we have an organization based here locally that, kind of like an employment agency where they wanted to hire 20 people to be housekeepers. And then finding out the various operations here, maybe only doing housekeeping, would that still be a legal possibility?
Labor contractors have kind of been weeded out of this process because they cannot prove the temporary need. A lot of times they are a labor contractor for housekeepers, for example, during a certain period of night at a time, and then they contract out labor for a different industry and they have year-round employees. So it's almost impossible for the labor contractor to prove a temporary need. So it's very difficult for them to obtain certification. It's a great question because it was a way to cut down on costs. Following one application, if all neighboring hotels, have the same need, but yeah, right. But, it's not allowed. Yes, sir.
What happens if they need to speak English? Is that a requirement you can ask for?
I mean, you can, because that's why a lot of the hospitality industry turns to Jamaica. So it really just, you can tell us what country you want your workers coming from. From Mexico, a lot of times they will not speak English. The education isn't very high there. So it really just depends on where you want your workers coming from, what industry.
Coming from and speaking English are two different things, right?
Yeah, yeah.
So can you say you need to speak English?
You can make that requirement, yes.
Okay,
Yeah,
thank you.
no problem. Any other questions? Yes,
Yeah,
sir.
so I want to say back what you said maybe, but you wouldn't be able to hire, so the DOL determines what you need to pay for an elderly. Let's use your 968 example, let's say that developer let's say it's here. You wouldn't be able to have, if I understood right with the quality thing, you wouldn't be able to have domestic employees paid less for doing those same jobs.
No, that is correct. They have to be paid that same wage.
So that would
If they're doing the same job.
You as an employer say, this is what I paid for that.
Yes.
And then when you have to pay to transport them from the community they live in, so we talk country, but that's gonna be a community within the country to your community. Now that makes a big difference whether they ride a horse or fly a jet, right?
Right.
How do you arrange that, or how do you?
If they cannot return to their home in a reasonable time frame within a daily commute as well, then you'll have to pay for them to relocate, just like you would for these workers coming from Mexico, if they want that job. Like we said, the position is going to be hosted on the national registry as well. So if you're advertising jobs here, and somebody wants to come from New Jersey and they say they want the job, you're not going to naturally pay for them to go back and forth to New Jersey every day, but you would pay for their one-way transportation.
Right. That first time getting them over, so like, we're in unison here, right?
Right. Mm-hmm.
So if we're gonna bring an employee into unison, and they're in Mexico, and they're deep in Mexico,
Right.
how do you, how do you arrange that? How do you get them? How do you process them? How do you control that cost?
Well, it's in the regulations, it's reasonable cost transportation. So we could help calculate what the bus transportation would be coming from Mexico from their place of recruitment. So it is only reasonable cost. So even if you have somebody coming over from Jamaica, they choose to fly first class. I think is what you're going. And reasonable cost is just regular airfare. Your only responsibility is to pay them, the reasonable cost of transportation of where they're coming from.
So the employee arranges getting there though? You don't have to.
Either way, you can do it either way, whatever you choose. If you want to make the arrangements and pay for it up front, you could do that, and reserve the flights or, charter a bus or whatever the case is, or they can make those arrangements and you reimburse them upon arrival.
Any thought on the ballpark cost per employee of all these things we've talked about outside of the hourly wage?
In regards to like all the filing fees and everything,
Your filing fees?
you know, I can go over the fees with you. The U.S. Citizenship and Immigration Service has a petition fee of $1,700. That's not per worker, that's just for the petition again. And then the U.S. consulate fees is $190 per worker. That's for every individual that you're going to schedule appointments for. Now, with our association, I can give you the direct cost for that is $4,500 for the employer membership dues. Again, not per worker, you know, but attorneys have different fees, agents have different fees, so that really just depends on who you go with to handle your paperwork process. Or if you try to do it internal, you can cut down some costs there. You know.
So I just heard $6,200 flat rate plus $190 a head.
Yep. That's why I was saying like the four, you know, plus transportation.
And some of the other legal paperwork type things that you could do yourself.
It's
And housing is their responsibility.
on the non-ag, that housing's their own responsibility. And food, yes. Daily transportation for food.
But then wouldn't you have to kind of figure in also the cost of, didn't you say if these people have to come in at a prevailing wage, correct? So that means when you advertise a job to a local, you have to do 21 days, that wage also has to be prevailing wage, correct?
That is correct.
So you have to pay now your U.S. workers and your local workers prevailing wage.
Yes.
And your non-local people prevailing wage, so then that jacks up even that cost
It could,
even
yep,
more.
yes. Depending if you're paying below,
Yeah.
depending if you're paying below federal, prevailing wage now.
Exactly.
Yeah. That's correct.
Exactly.
Yes.
Local workers get paid more than prevailing wage, they pay exactly.
They could be paid more than prevailing wage. The local workers can be paid more. The HB workers could be paid more as well. Department of Labor is just going to set a bar that you have to meet at least. Now, if there are additional wages that they can make, if you know, like they came back 968 and you know you're going to pay 1050, that's something you have to put in the job order, the advertisement. So you can't just advertise 960 because it's the bare minimum when you know you're going to pay more, because the U.S. workers have to acknowledge that there's an opportunity to make more money. So that is important. Yes, sir, do you have a question?
Yeah, I'm getting kind of a feel for it. But- So let's say our company wanted to hire 5 people. And I think I got to handle everything but the lodging. How do these people coming into Munising, I mean, get lodging? I mean, it's their responsibility.
It's their financial responsibility. You as an employer are going to have to make sure they have a place to stay upon arrival. Like I said, many employers will set them up in hotels before they find an apartment or house, trailer house, whatever the case is that's available for them. Or you make arrangements before they get here and have a house ready for them to rent. And they
So
pay the rent direct.
let's just follow that line of thinking here. Let's say they're making $10 an hour, $400 a week, $1,600 a month. You have them for 3 months, and then you charge them for the housing out of the $1,600?
The employer wouldn't charge them the housing. You do not want to get involved in charging them for housing.
I mean, to
But
rent-
they would have to pay rent, yes.
So the rented place in Munising that's reasonable is going to be $500 to $750 a month.
And many of the workers will stay together to cut down on those costs, you know, because they're coming over just as, they don't have their families or anything with them. So to cut down on those costs, they'll be sharing an apartment or a house.
But it's up to them to find a place to live.
There's nothing in the regulations that say you have to do otherwise. Many employers go to the extent of renting a house for them, some of them, even, you know, because when you're looking at that short of a time period, it becomes more difficult, you know, because you can't sign an apartment for, you know, a lot of times less than a year. You know, but some employers will do the fact if you have a longer season, there may be some other arrangements you can make prior to them arriving, but the financial responsibility is of the workers. Yes, ma'am.
So if you did rent the house for them, say, how would that work? So say I rented the house for these folks, do I just like set them up with the landlord? Is that what you mean?
Yes, set them up with a landlord.
And then
You
they
don't
would
want to get
take
into
from
any payroll deductions
Right,
or anything
okay.
like that. You can, and the reason you can, if you're going to go that route, even if you personally own a house that you're going to rent to them, it's something that has to be listed up front in the job order and the advertisements, and make sure that it's available for U.S. domestic workers as well. Yes, ma'am.
Is there any way that you, So if you own a property that has the ability to accommodate and to feed whoever it is you want in a non-agricultural state, is there any way you can work that into, instead of having a reimbursement for food, and can you require them to stay there? And can that then be a portion of their wage?
No, it cannot be a portion of their wage. That prevailing wage has to be met on the hours that they are worked. You know, you cannot require them to stay there either. It has to be optional. But they can't pay you rent. And you can, like I said, you can't even go as far as deducted it from their pay. But when you go that far, any deductions have to be disclosed in the job order. So you have to make that available for anybody who's going to be advertised, you know, looking at the advertising. And local.
Ultimately, it would behoove a community to develop a rental property for these types of things and then have somebody else administer that
Right.
rental.
Right. Yes, ma'am.
Is there some type of a different program out there where, workers come over on like a student visa or some type of a student experience or within a certain age group or whatever, and they're coming to the US for some type of cultural experience, to live here and work here for a certain period of time, is that a less expensive program?
I don't know that it's less expensive. A lot of the regulations still apply. It's called the J1 visa program. They don't have as many requirements and they don't have to work for a certain employer. They do have to, we don't handle the J1, but from what I know of it, the differences are you're not tied to one employer. It has to be a culture exchange program. So if you're looking for a housekeeper, it's harder to be able to prove that they're going to be experiencing a culture exchange while they're just, you know, cleaning rooms. But if they're going to be your hostess, you know, or they're going to be working in the amusement park where they're, you know, working with individuals, and it is a shorter time period as well because they have to be college students in their home country. So it's going to be the time period that they're off college, so a few months in the summer. Yes, ma'am.
So, I'm probably going back and forth. So you're, I think it's back to your question. She was asking if we could pay a local worker more than other worker coming in at prevailing wage. So how does that work in though to, I'm not a lawyer, fair labor, you know what I'm saying? I'm saying, okay, you know, you're from Utica, I'm just throwing this out there, and I'm willing to, you know, that, and this is your first time working here, and I'm willing to pay you $10 an hour, and then, you know, Bob comes in from Mexico, and I'm only, he's doing exactly the same thing, same amount of experience, but you only have to pay him $9.50. But you can't do the other, vice versa.
Right, but you cannot do the vice versa, and as I was explaining to her, if you know the job position is going to pay more, you are required to put a wage range or any other financial benefits that the worker can receive. So if you know the job is paying $10 an hour, you can hire a domestic worker for $10 an hour. The Department of Labor is just setting the minimum. So you do have to treat them the same. So if you're going to be paying $10 an hour, the prevailing wage comes back at $9.68, you're still going to have to pass $10.
What if you bring somebody back, maybe you answer this, maybe you bring somebody to one of these repeat workers, and it's fantastic, Bob is a fantastic worker, I'm bringing him back every year. Are you allowed to pay Bob, who's a returning worker on this visa, more money than the local worker?
One thing that you would want to include in your job order to be very transparent is that the employer has discretion to give a raise or a bonus as you see fit. So that's something you would work into your job order and your advertising. So at least local people know that the set rate is $9.68. But if I work hard and try to do more, I do have the opportunity to get a raise. So that's what covers you when you do have those returning workers to get paid more than.
So I can bring in Bob, he's been coming, he came last year, I'm gonna bring Bob back in, I wanna give him 12.
Right.
But that doesn't mean I have to advertise for $12 an hour, that 21-day period for the local.
Correct. Correct. As long as you have something in there that says that you have the discretion to give them a raise or bonus, you know, a lot of employers do year-end bonuses, things like that. Yes, sir.
Have you ever done a cost-benefit analysis just to understand at what point, you know, how many employees it makes sense to do this financially? Because you guys are just crunching numbers here. In one employee, you end up really you're paying that employee $20 an hour.
Right.
That's what it would end up. So, how many employees would you bring over if you guys as your agency or?
You know, we look at the membership and all and kind of see where that evolves. Like I said, you know, the bare minimum really falls around 4 or 5 workers, but it has a lot to do with the different industries. and where you're located. We said 968 for a housekeeper in this area in the county. I mean, you could be mowing yards in Massachusetts making $16 an hour. You know, but then the cost of living takes in effect there as well. So the prevailing wage is so different, every county, every state, and the industries as well, you know, so, but we do see really a bottom line, it's around 4 or 5 workers making cost of living. Yes?
What do they take into account when they determine the prevailing wage?
Job description, job duties, Department of Labor takes ONET in regards to code and take the job duties in counties. Every county they're going to be working in the job description, they'll set them up into a certain category. Housekeepers has their own code, landscapers have their own code, you know, all different codes that the Department of Labor will determine what the job is, and then the counties as well. So that's all they take into
Well, that's on
consideration.
the supply side, but on the demand side, it also is determined by the cost, the average cost of food, shelter, clothing.
On the other end,
In
yes.
the area that's targeted.
Correct. Yes, ma'am.
So contracting businesses, for example, if here in Alger County, a particular position pays $12 an hour, but they also got to utilize them over in Marquette on a job over in Marquette County, and that's $14 an hour, they got to pay the $14.
If it's on one application, yes. You can file separate applications depending on the job and the employer to keep those two completely separate.
You might be working in 3 counties, so you got
Yes.
to do 3 different applications.
One application to list all counties, but you'll be required to pay the highest prevailing wage of each county, for all the workers on that one application.
Is there any need to compete? So you mentioned somebody can mow lawns in Manhattan for $16 an hour, and if we're only putting out a job at $9.68 an hour, is there a chance that you won't fill your job because everybody wants to go to Manhattan first? I mean,
What if they look at cost of living?
Yeah, the cost of living takes a lot of
Okay.
place, but I've never, yeah,
Is there any competition, or they take whatever you give them?
yeah, they take whatever, I mean, still comparison to what they're making, they're looking at what they're making at home, you know, $10 a day.
So at $9.68 an hour hospitality job, you would have people lining up this kind of thing?
We never had any issue with that. Yes, ma'am.
If the region can't really absorb it, but there's not a lot of housing available, is that something that's already been proven when the business starts working with you guys? Or, so like if the employees come here and they can't find housing, or they choose to camp or sleep on the beach and it's not necessarily a legal way to house, does the employer get trouble for that? Is that enough to get the employer that?
It's not on the H-2B side, non-agricultural side. You know, I don't know how long the employees will stay happy and returning, you know, if they don't have great living standards.
But
But-
it would cut their costs down
Yeah.
too, so I'm just saying like if they try to, you know, 'cause we have miles and miles of beaches which you're not supposed to do that. but
Right.
if they do that and then they get in trouble with the employer.
I mean, if they get in trouble like with the state because it's illegal, oh, I
They're
get
not supposed to
you.
do
Right,
that, but they're choosing,
Yeah,
and
it-
I don't want to pay $500.
right. Anything that they do here that's, you know, they get in trouble with, even if it's a, you know, DWI, for example, or something that they get, you know, go into jail, that nothing's the responsibility of the employer, unless it's on the job, of course. You know, so that would kind of fall into that category. You know, you do find many of them living, you know, as many as they can in one house to cut down the cost, especially for these short time periods, you know. It's kind of what they're accustomed to, but any state violations or anything like that, it's not going to come back.
But the employer might have to transport it back.
Back home, yes, yeah, they have to.
So, go ahead. No, I was just gonna stand up and say we probably got time for maybe 2 more questions, and then you're around, we take
Yes.
a break immediately following, so we'll just get 1 or 2 more questions.
So let's say the housing, closest house is about a half hour away now, doesn't the employer need to provide that transportation back and forth to there, or?
You know, they have to be able to get to work, and it kind of falls into the category if they have any ties here in the community already, or if it's their first time in the area. If it's their first year, a lot of times the employers will have to go and bring them to work on a daily basis. It's nothing that's within the regulations. You know, but if they're living 30 minutes away and they can't get to work, you know, what are they going to do? If there's not public transportation available, you know, that's something you'll have to overcome. You know, now when the benefits really come to place when they're returning workers, they get driver's licenses. A lot of times they'll purchase cars and things like that to get them back to work and take to their home country. after a while, but for that first year, it's some of the hurdles we will have to overcome if you don't have public transportation available for them, and they're living that far away. Anybody else?
Okay.
Thank you, and I will be around.
You got